Welcome back viewers. I am your host Urvashi Chauhan and you are watching Live Law. In this video, I will cover part 3 of the 100 important judgments of the Supreme Court from the year 2024. Part 1 and part 2 of this series are already out on our YouTube channel, so in case you have missed it, do remember to watch. Whether you are a law student, a practicing lawyer or simply someone curious about the impact of judicial decisions, this compilation is for you. I will tell you in brief about the judgment. We will also display its title and quorum for you on the screen. For detailed reading, you can always refer to complete coverage on our website at www.livelaw.in. So let us start the part 3 covering another set of 25 judgments. In a significant judgment, the Supreme Court bench comprising Justices J.B. Pardiwala and Ujjwal Bhuiyan in Sheikh Javed Iqbal versus State of Uttar Pradesh had granted bail to an under trial prisoner charged under Unlawful Activities Prevention Act 1967. The Supreme Court here held that a constitutional court can grant bail despite statutory restrictions if it finds that the right to speedy trial under Article 21 of the Constitution has been infringed. The Supreme Court bench comprising Justice Sudhanshu Dholia and Justice Ehsanuddin Amanullah had reiterated that purpose of making check bounce an offence was to ensure reliability of checks and compensatory aspect of remedy under the Negotiable Instruments Act of 1881 has priority over the punitive aspect in such cases. This bench in New Win Export and Another versus A. Subramanyam observed that courts should encourage settlement in check dishonor cases. Moving ahead, the bench of then CJI D.Y. Chandrachud, Justice J.B. Pardiwala and Justice Manoj Mishra dismissed an arbitration petition seeking appointment of an arbitrator 11 years after checks were dishonored on the ground that the claims were barred by limitation. The court observed that initiation of proceedings under Negotiable Instruments Act for check dishonor does not constitute continuing cause of action for initiating arbitration under the Arbitration and Conciliation Act. The title of this case is Elfit Arabia and Another versus Concept Hotel Barons Limited and others. Next is the matter of Rewa Tollway P Limited versus the state of Madhya Pradesh, where the Supreme Court observed that a person cannot claim any enforceable legal right based on an executive action that is later modified by the state legislature in the larger public interest. In a sense, the bench comprising Justices Vikram Nath and Ehsanuddin Amanullah observed that neither the right to legitimate expectation nor promissory estoppel can be asserted based on executive actions that the legislature subsequently changes in the public interest. Next is the important case of Parvinder Singh Khurana versus Directorate of Enforcement, where the bench comprising Justice Abhay S. Oak and Justice Augustine George Massey held that bail orders should not be normally stayed. Setting aside an order of the Delhi High Court which had stayed the bail granted in a money laundering case, the Supreme Court stated that bail orders can be stayed only in exceptional circumstances. In the case of Vanshika Yadav versus Union of India, the Supreme Court refused to cancel the NEET UG 2024 exam on the grounds of paper leak and malpractices. The bench consisting of the then CJI D.Y. Chandrachud, Justices J.B. Pardiwala and Manoj Mishra observed that there was no evidence to suggest that the leak was systemic or that it compromised the integrity of the entire exam. Another bench of the top court comprising Justices Sanjeev Khanna and Dipankar Datta interpreted Section 20 of the Contempt of Courts Act 1971 in the case of S. Tirupathi Rao versus M. Lingamaiah and others. The court held that an action for contempt must be filed within 1 year from the date the alleged contempt occurred and not beyond that time frame. Additionally, it clarified that period of limitation is not extended by the last of repeated representations made by a party unless filing of such representations is statutorily mandated. In a notable decision relating to Insolvency and Bankruptcy Code of 2016, the Supreme Court held when the insolvency resolution of a corporate guarantor will not prevent the creditor from initiating another insolvency process against the corporate debtor for the balance debt. Approving the decision of the NCLT to admit the insolvency petition against the debtor, the bench comprising Justices Abhay S. Oak and Pankaj Mittal, while deciding BRS Ventures Investment Limited versus SREI Infrastructure Finance Limited, held corporate guarantor would be entitled to step into shoes of the creditor to recover loan amount from corporate debtor. In the next update, the Supreme Court 9-judge Constitution Bench in Mineral Area Development versus Steel Authority of India held by an 8:1 majority that states have the power to levy tax on mineral rights and that Union Law, that is Mines and Minerals Development and Regulation Act of 1957, does not limit such power of the states. The 9-judge bench which delivered the judgment was headed by the then CJI D.Y. Chandrachud and comprised of Justices Hrishikesh Roy, Abhay Oak, B.V. Nagratna, J.B. Pardewala, Manoj Mishra, Ujjal Bhuya, Satish Chandra Sharma and A.G. Massi. The Supreme Court, in a matter heard by the bench of Justices Vikram Nath and Prashant Kumar Mishra, held that an authorized signatory of a company could not be considered a drawer of a cheque and therefore could not be directed to pay the interim compensation to the complainant under Section 143A of the Negotiable Instruments Act. The title of this case is Shri Ram Industries versus State of Uttar Pradesh. The apex court upheld the requirement in several states that individuals seeking appointment as judicial officers must be proficient in the local language. The bench, consisting of then CJI D.Y. Chandrachud, Justices J.B. Pardewala and Manoj Mishra, while deciding the matter in the Legal Attorneys and Barristers Law Firm versus Union of India, dismissed a petition challenging the condition imposed by Public Service Commissions of the states of Punjab, Karnataka, Maharashtra and Odisha. Next, in the case of MC Mehta versus Union of India, the Supreme Court lifted the condition it had imposed on 10th August 2017, which required a pollution under control certificate as a prerequisite for obtaining third-party insurance for vehicles. The bench, consisting of Justices Abhay S. Oak and A.G. Massi, granted relief by allowing an application filed by the General Insurance Council, which raised concerns regarding the 2017 order. In Common Cause and Another versus Union of India, the Supreme Court dismissed petitions seeking to set up a special investigation team to investigate the alleged instances of quid pro quo arrangements between corporate and political parties through electoral bonds donations. The bench of then CJI D.Y. Chandrachud and Justices J.B. Pardewala and Manoj Mishra observed that it would be premature and inappropriate to order an investigation under the monitoring of a retired judge when the remedies available under the ordinary law governing criminal law procedure have not been invoked. In a significant ruling, the Supreme Court bench of the then CJI D.Y. Chandrachud and Justices Narsimha, J.B. Pardewala held that the Lieutenant Governor of Delhi has the power to nominate aldermen to Municipal Corporation of Delhi without the aid and advice of the Delhi government. The court ruled that the power was a statutory power flowing from the Delhi Municipal Corporation Act of 1957 and hence the governor need not act as per the aid and advice of the Delhi government. Since it was a statutory power given to the LG and not an executive power of the government, the LG was expected to act as per the statutory mandate and not as per the aid and advice of the Delhi government. The case is titled Government of NCT of Delhi versus Office of Lieutenant Governor of Delhi. In an important ruling from the bench of Justice Bela M. Trivedi and Justice R. Madhavan in the matter of Pro Nits versus the Board of Directors of Canara Bank, concerning revival of entities registered under Micro, Small and Medium Enterprises Development Act, the Supreme Court observed that banks are not empowered to classify the loan accounts of the MSMEs as non-performing assets without following the mandatory procedure laid down in the instructions for Framework for Revival and Rehabilitation of MSMEs issued by the Ministry of MSME. Next, in the important case of Kishore Chandra Changan Lal Rathod versus Union of India, where the Supreme Court held that nothing precludes the constitutional courts from checking the validity of orders passed by Delimitation Commission on the touchstone of the Constitution if an order is found to be manifestly arbitrary to constitutional values. The bench of Justice Surya Kant and Justice Ujjal Bhuya, while passing passing the order, said that restraining the Constitutional Court from invoking the powers of judicial review against every action of delimitation exercise would lead to a situation where the citizens would not have any forum to plead their grievances. Taking suo motu notice of an unusual order passed by the Punjab and Haryana High Court, a 5-judge bench of the then CJI Chandrachud, Justices Sanjeev Khanna, B.R. Gawai, Suryakant and Hrishikesh Roy of the Supreme Court expunged the unwarranted remarks in the High Court's order, criticizing a stay order passed by the top court. Along with this, the bench also issued a word of warning to the High Court judge, demanding more caution while passing orders. Next is the controversial liquor policy case, that is Manish Sisodia versus Directorate of Enforcement. The Supreme Court bench of Justices B.R. Gawai and K.V. Vishwanathan here allowed the bail plea of former Delhi Deputy Chief Minister and Aam Aadmi Party leader Manish Sisodia in relation to the liquor policy case. The court allowed the bail applications filed by Sisodia in both CBI and ED cases, considering the delay in commencing the trial in the liquor policy case. This judgment also laid down important principles regarding bail under PMLA. In yet another important case of Gaurav Kumar versus Union of India, a bench led by the then CJI Chandrachud and comprising of Justices J.B. Pardewala and Manoj Mishra held that enrollment fee cannot exceed 750 rupees for advocates belonging to the general category and rupees 125 for advocates belonging to SC and ST categories. The court categorically held that state bar councils cannot charge any amount over these specified amounts under the head of miscellaneous fee, stamp duty or other charges. The court specified that all fees charged by the bar councils under whatever name as precondition for enrollment would qualify as enrollment fee. Therefore, money collected by bar councils in the name of verification fee, building funds, benevolent fund, etc., which are stated to be one-time payments at the time of enrollment would be enrollment fee. Moving ahead, a constitution bench comprising the then CJI D.Y. Chandrachud and Justices Hrishikesh Roy, P.S. Narasimha, J.B. Pardewala and Manoj Mishra ruled against clauses allowing public sector undertakings to unilaterally appoint arbitrators to decide disputes with private contractors. The bench held that while PSUs can maintain a panel of potential arbitrators, they cannot compel the other party to select its arbitrator from the panel. The court was considering the validity of an arbitration clause which prescribed that appointment of the arbitrator will happen from a panel of arbitrators curated by one of the parties, which is mostly a public sector undertaking in majority of the cases. The Supreme Court in the matter of Jalaluddin Khan versus Union of India held that bail is the rule, jail is the exception, even in special statutes like UAPA. A bench of Justices Abhay S. Oak and Augustine George Massey held that if the conditions in the special statute for the grant of bail are met, then bail should be granted. In a suo motu case, Justices Abhay S. Oak and Ujjal Bhuiyan delivered a significant judgment addressing controversial remarks made by the Calcutta High Court in its decision from 18th October 2023. The bench set aside the High Court's judgment and its controversial remarks such as adolescent girls should control their sexual urges. The Supreme Court emphasized that judges must decide cases strictly in accordance with the law and refrain from expressing personal opinions in their judgments. In an important matter, the bench comprising Justice Bela M. Trivedi and Justice Satish Chandra Sharma held that non-fixation of the cutoff marks for category of persons with benchmark disability falling under an overall horizontal reservation could neither be said to be arbitrary nor violative of fundamental rights. This was the matter of Rekha Sharma versus the Rajasthan High Court. Now coming to the case of Girish Gandhi versus the state of Uttar Pradesh and others. A bench of Justices B.R. Gawai and K.V. Vishwanathan in this case held that if an accused involved in multiple cases is enlarged on bail and is unable to find multiple sureties, the court must balance the requirement of sureties with his right to personal liberty guaranteed under Article 21. Justices J.B. Pardewala and Manoj Mishra in their judgment in Shahjahan Skaria versus State of Kerala held that merely insulting a member of a scheduled caste or scheduled tribe does not constitute an offence under the SC and ST Prevention of Atrocities Act 1989 unless it is proven that the accused intended to humiliate the individual specifically based on their caste identity. Thank you for watching. Please make sure to like, share and subscribe to our channel and stay tuned for part 4 of this series.